Hi, Bill Henshaw here again for the Constitutional Crisis Channel. Today's subject, Traffic Court, quote-unquote, Part 2. Now, the first thing you notice, you go in there for the traffic arraignment, quote-unquote, and if you listen to earlier videos, you're going to know that's not even close to the constitutional standard for an arraignment. I mean, you get in there, they call your case, traffic commissar gets you in there and says, how do you plead? Guilty, not guilty, or sometimes nolo contendere, no contest. None of those are valid pleas, and this is particularly true since the DA will never have filed a response to your timely demand for a bill of particulars. You're entitled to know the nature and cause of the accusation and the elements of the crime. You don't know that, there's no way you can make a voluntary, knowing, and intelligent entry of a plea, and the court thus does not acquire jurisdiction because of it. And by the way, that voluntary, knowing, and intelligent, that's the reference standard for the Supreme Court of the United States to find a waiver of rights. Case on that one is Johnson v. Zerbst, Johnsson v. Zerbst, 358 U.S. 408, I believe. I think I'm getting the citation wrong, but I'll get it for you. And they said voluntary, knowing, and intelligent, and they can't find a waiver like that, and the entry of plea is highly jurisdictional. It gets worse because you refuse to enter a plea and stand mute, which is exactly what you should do. The traffic commissar is going to enter a plea for you. Just as they think they have an agency relationship with you, since you're one of their 14th Amendment citizens, otherwise known as wards of the state, and they think they have that relationship. They don't. They're not your attorney. They can't validly enter a plea. That's a major faux pas. And wouldn't you know, in California, it's Penal Code Section 1024. And in Idaho, it's a similar situation. I don't recall the statute there, but the same objection. And the statute's been on the books for 150 years, but there are no case law decisions. The only way that happens is other people like me, I'm not the only one, have realized this, have taken the issue up to the higher courts, and they quietly dismiss the case, and they call the traffic court and tell them to take the case off your records, get it out of here. We don't want anything on the record. If people learn about this issue, we're dead. And they're right. Oh, by the way, the citation for Johnson v. Zerbst, 304 U.S. 458. Little slip of the mind there, senior moment. So anyway, the other thing that they want you to do is file a demurrer, which that's a valid thing. You can challenge, the ticket. But the problem with it is you can't bring any substantive challenges, only statutory things, which is no good. And the demurrer is a general appearance. That gives them jurisdiction, which they don't tell you. You would need to make a special appearance, but there's no way to do it. Even if there were, it may be worse because the Supreme Court of the United States has said, case is York v. Texas, Y-O-R-K v. T-E-X-A-S 137 U.S. 15, that if you appear, even making a special appearance in a trial court that doesn't otherwise provide for it, you have consented or stipulated to the jurisdiction, and we're not going to hear your case. What they're saying is you have to stay out of the court and go right from the trial court, quote-unquote, to the Supreme Court of the United States and take the matter up there with a court that does have jurisdiction of your issues. This, by the way, is not wild. This has been known to happen. Well, one of the cases I'm well aware of, called Thompson v. Louisville, as they say there, Thompson versus Louisville, 362 U.S. 199. It's a case where Thompson got convicted of loitering in a deli while he was waiting for a bus. He got fined $50. Now, this is 1959, so that was a good chunk of change. Well, they went right from the Louisville Police Court to the Supreme Court of the United States, and they took the case because they said, yeah, while the issues and the penalties here are small, the constitutional issues aren't. And that's how we want to get there. We have no remedies in their court, and I believe we can do the same thing. And in fact, they reversed his conviction under this statute and the $50 fine, never had to pay it. That's ultimately where we want to go. So stick with me, you're going to learn how to do all of it. Thank you.